good morning and happy Basant Panchami to all the esteemed judicial officers of the state of Punjab, Haryana and Chandigarh Judicial Academy. I, Karuna Sharma, faculty member, Chandigarh Judicial Academy, welcome you all to today's webinar. The topic for today is expeditious disposal of execution cases. And we have with us Sir Shri Amrinder Singh Shergill, Learned Additional District and Sessions Judge, cum faculty member, Chandigarh Judicial Academy. I welcome you, sir. Sir, we officers face a lot of difficulty during the execution of cases, and it is always a tough nut to crack. Sir, I will be asking certain questions on behalf of all the judicial officers, and if still any question remains, then the judicial officers are requested to post their queries on the space provided. We will take up those queries at the end of the session, but I will request you to kindly post only those queries that are related to today's session. Over to you, sir. So my first question today is related to the topic, and that is why expeditious disposal of execution cases.
Thank you, ma'am. Good morning, all officers. We have all conducted the trials of civil suits at one moment or the other. What we have witnessed is a party knocks at our door, the doors of a civil court, for obtaining a relief with respect to his or her civil right. That takes place through institution of a plaint, and we call that party as plaintiff. On the plaint presented by that party, the civil court gives notice to the opposite party against whom the plaintiff party has approached for obtaining relief. Thereafter, that party appears. Plaintiff also has pleaded his case in his plaint. The opposite party in his defense also pleads his or her case, and since he is defending the case of the plaintiff, we refer him as defendant. After scrutinizing their pleadings, their record, their documents, and hearing them, a civil court frames issues on which parties are at variance, are at dispute. Thereafter, one by one, parties are called upon to lead their evidence. Plaintiff leads the evidence, the defendant cross-examines the plaintiff witnesses. Thereafter, defendant leads the evidence, plaintiff cross-examines the witnesses. Thereafter, the plaintiff is awarded an opportunity of rebuttal, if there is anything to rebut. Thereafter, the litigation in between the parties is decided through a judgment, and on the basis of that judgment, a decree is drawn, which becomes the subject matter of execution. The story do not end here. The aggrieved party is provided a remedy to prefer an appeal. It is a statute provided remedy, and after availing those remedies regarding appeal, a decision becomes final. And when a decree attains finality, it becomes subject matter of execution. So we have to sensitize ourselves that the person who has moved an application for seeking execution of a decree was the person who has knocked at our doors by instituting a plaint, by filing a civil suit, and after a long drawn trial, a judgment has come in his favor on the basis of which a decree has been drawn. So that person looks at a civil court that if a judgment on the basis of which a decree has been drawn has come in his favor, which has attained finality after a long drawn battle, then in the interest of justice, he is expected to achieve the fruits of his decree as early as possible. So, to have a successful litigant achieve the fruits of his decree at the earliest, you see, let us remind ourselves that there is a framework of the code. Under that framework, there comes Order 1. Order 1 talks about parties to the suit. It expects that whosoever has any grievance with respect to the right claimed by the plaintiff should be joined as parties. Who are opposing the plaintiff to be joined as defendants. And there is Order 1 Rule 10 CPC provision, which enables a party who is a necessary party for the fair and final adjudication of the matter to become a party if it has not been pleaded by the plaintiff. So, under Order 1, all the parties which are necessary, whose presence are necessary for the fair and final adjudication of their dispute, are arrayed under Order 1 as parties to a civil suit. Then comes Order 2. Order 2 talks about joining of all reliefs, all claims, and causes of action. Whatever claim a party intends to take, he is at liberty to take it in the said civil suit. Whatever the defendant intends to take, the defendant is at liberty to take the said defense in his written statement. If a claim is abandoned, is not taken, is left out, then that party is precluded from obtaining the same relief through a subsequent proceeding. It is only on account of the principle of public policy that if there is a dispute, it has to be decided in totality. Whatever is the dispute in between the parties, it has to be decided in totality, in completeness. And whosoever is the party who is raising a right, title, and interest over the subject matter of dispute, that should be arrayed as a party. So in the presence of the necessary and actual parties, all the claims in between the parties are settled. If this is so, the judgment debtor against whom the decree holder files an application for seeking execution of his decree is the person who was present throughout the litigation, in the civil suit also and before the appellate courts also. So it becomes more incumbent upon a civil court that to such a successful litigant, the fruits of his decree are awarded, are given at the earliest, and the Honorable Supreme Court demands that it should be given within a period of 6 months. Yes, ma'am, over to you.
Yes. Thank you so much, sir. Sir, my next question is whether there is any time limit prescribed for the executions.
Yes, ma'am. The Honorable Supreme Court, in a recently given judgment, namely Rahul S. Shah versus Jinendra Kumar Gandhi and others, citation is 2021 6 SCC 418, has asked the civil courts through a direction, a mandatory direction, to conclude the execution applications within a period of 6 months. And if within the said period of 6 months, a civil court is not able to conclude the execution application, then that civil court is to give reasons for the delay. Yes, over to you, ma'am.
Yes, sir. Sir, I would like to ask, or I would like you to deliberate upon this. What are the other directions which are given in this particular case that you have just referred?
Yes, ma'am. There are different directions given in this very judgment, which is very relevant on the topic of expeditious disposal of execution applications. Before going to the directions, I would like to visit the judgment and the observations made therein by the Honorable Supreme Court, which shows us the path and the direction which we can take for the expeditious disposal of execution cases. The opening observation in para number 2 of the judgment is that there is a constant abuse of procedural provisions which defeats justice. You see, the intention of the legislature to insert the provisions in the Code of Civil Procedure, and especially Order 21, which deals with execution, is that no injustice is meted out to any person. But it has been seen that under the garb of those provisions, the JD, who is to execute the decree, who is to honor the decree, delays it by raising frivolous, spurious objections and obstructs the execution of the decree. It results in defeat of the justice. In this very matter, the execution was pending before the courts for a long 14 years period. And the Honorable High Court has imposed a cost of rupees 5 lakh. In this case, the Honorable Supreme Court has upheld it by observing it that it is very much reasonable. It is very much reasonable for thwarting the several attempts made by the decree holder to realize or to obtain the fruits of the judgment secured by the decree holder. You see, these costs are imposed upon the judgment debtor when he thwarted, made unsuccessful the several attempts which the decree holder had made in between that 14 years period to obtain the fruits of the judgment, to obtain the fruits of the decree which he has secured through a court of law. So the Honorable Supreme Court has acknowledged that imposition of costs, and that too reasonable, not 50 rupees or 100 rupees, substantive cost should be imposed so that we can take the judgment debtor to the task and make the decree holder realize the fruits of his decree on the basis of the judgment which has been given in his favor by a court of law after a long drawn trial and after consuming of all opportunities of appeal. The Honorable Supreme Court in this very judgment has also called upon the civil courts to use their powers. It is seen that either we do not know the provisions which empowers a civil court for the expeditious disposal of a case, including an execution case, or we do not have the dedication, the strength, the calling, or the firmness for invoking those provisions in delivering the justice to the decree holder. So the Honorable Supreme Court has called upon in this judgment that civil court or any court who is tasked with the execution process should use its powers, including the power to set down and proceed the party ex parte, and the power to impose suitably heavy costs, not minor, costs not just in the name of the cost, but those costs which should be heavy in the facts and circumstances of the case. And you see, once the Honorable Supreme Court has given a mandatory direction that an execution process is to be concluded within 6 months, both the parties are having its knowledge. So both the parties are expected to cooperate with the executing court in completing the process of execution application within 6 months. If after knowing it, a party raises an obstruction or do not give the required cooperation in disposal of the execution process, then it becomes incumbent on the civil court to exercise the powers which the code has given, and those powers are also to be supplemented by imposing suitably heavy costs. The word used by the Honorable Supreme Court is suitably heavy costs. The Honorable Supreme Court has acknowledged that due to the delay which is caused during the process of execution, the troubles of the decree holder starts. The remedies which are provided for preventing injustice becomes the very much forum to misuse them for causing injustice to the decree holder by preventing the timely implementation of the orders and executions of the decree. The Honorable Supreme Court in the said judgment has acknowledged that in the year 1872, long back, the Privy Council in a case, the General Manager of Raja Durbhunga versus Maharaja Kumar Ramakut Singh, 1871-72, 14 moves IA 605 has observed that the actual difficulties of a litigant in India begin when he has obtained a decree. Obtaining a decree is also difficult, but actual difficulties, it was so acknowledged by the Privy Council long back in the year 1872 that actual difficulties of a litigant in India begin when he has obtained a decree. The Honorable Supreme Court has also visited another law laid down by the Honorable Supreme Court also, in which the Honorable Supreme Court has opined. The citation is Shubh Karan Bubna alias Shubh Karan Prasad Bubna versus Sita Saran Bubna, 2009, 9 SCC 689. What was opined in the year 2009 by the Honorable Supreme Court is that the execution proceedings which are supposed to be handmaid of justice, which are supposed to be used for the delivery of the justice and subserve the cause of justice, are in fact becoming tools which are being easily misused to obstruct justice. So the very purpose of this webinar is to visit those provisions, to sensitize you all colleagues regarding those provisions which empowers a civil court to check such a misuse. And the second aspect of today's session would be that if there is a provision, it should be carefully implemented. Just to take an example, if a civil court during the execution proceedings issues a warrant for attachment of the property of the JD, and if ultimately that property is objected to be exempted under Section 60 under the law of the land from being attached, then a precious important period will be wasted, time will be wasted, the justice which we have to deliver to the decree holder will be wasted. So second aspect would be to carefully scrutinize the provisions before issuance of the process so that for the fault of the court, the party should not suffer. The sufferance is delay in realization of the fruits of the decree. First thing which comes as far as the execution process is concerned is the questions which are to be determined by an executing court. I am just listing the judgment of the Honorable Supreme Court only, and that is section 47 of the code. You see, the party raises the objections, we consider the objection and we adjudicate upon the objection. But there is a boundary within which those objections can be taken. There are two essentials which are requisite, which have to be kept in mind for looking into the objections so taken by either the judgment debtor or any person on behalf of the judgment debtor being a partyman of the judgment debtor. The first and the foremost is that the said question must be the one which is arising in between the parties to the litigation. So going back to order 1 and order 2, which I have just mentioned, the parties are at liberty to join any party which is a necessary party without whose presence the dispute cannot be adjudicated completely. Thereafter, under order 2, the parties are required to take all the claims for the grievances they have, the cause of action they have, so that the dispute in between them is decided in completeness, in totality. If a dispute has been so decided, then there remains nothing to be disputed at the stage of execution proceedings. Thereafter, coming to the second thing is that the dispute which is raised by a party to the litigation during the execution proceeding should relate only and only to the execution, to the discharge, or to the satisfaction of the decree. So it is a very limited area under which we can entertain the objection. I will be visiting the provisions in the Honorable Rules and Orders of the Honorable High Court, wherein it has been given to us that these objections have to be considered in a summary manner. The objective of this section is to prevent unwanted litigation and dispose of all the objections as expeditiously as early as possible. You see, one more thing which we all basically know is that executing court cannot go beyond the decree. If an executing court cannot go beyond the decree, and it is the decree which is to be honored by the executing court through its execution, then what remains else therein? You see, we cannot allow the parties in the execution proceedings to start a retrial. The stage of the trial is over. Now it is the stage during which the decree passed by a court is implemented, is given effect to, is enforced against the party against whom that decree has been given. One more general practice which the Honorable Supreme Court observed in the said judgment is that the court invariably issues notice at each and every stage. You see, it is not at all necessary to issue notice to the judgment debtor in whose presence or after giving notice to whom a judgment has been passed by a civil court on the basis of which a decree is drawn. We'll visit those provisions in detail. We waste precious time in giving notice, show cause notice to the judgment debtor in each and every case which is not required. Then the Honorable Supreme Court has also mentioned about invoking the provisions of appointment of receiver by the court. Through appointment of a receiver by the court, the administration of the property is taken over by the court. If the administration of the property is taken over by the court, then it becomes very easy for implementing or for executing the decree. Thereafter, the Honorable Supreme Court has vested Rule 35, Order 21, which empowers a civil court by ordering a removal of any person who refuses to vacate the property by the decree of the court, who is bound by the decree of the court to vacate the property, but he refuses to vacate. Such a person can be got removed from the property by the order of the court, invoking the provision of Rule 35 of Order 21. Then is Rule 98, which we will deal in the later part of the session. Under Rule 98, for creating hindrance, resistance, obstruction, even after the order of the court, such a defaulter can be sent to civil prison. The Honorable Supreme Court has observed that these provisions are rarely invoked by civil courts while trying execution cases. The Honorable Supreme Court has also called upon the civil courts to play an active role, not participative role, but an active role. If a civil court plays an active role, then there will not arise an occasion when any decree is passed for whose execution difficulty can be faced. So to avoid a difficulty for being faced for executing a decree, a civil court, while passing a judgment, while drawing a decree, should play an active role. You see, what is expected from a civil court is that the decree which is passed by a civil court should be very much clear. That decree should be unambiguous. There should not be any ambiguity or confusion in the decree. And that decree should be a decree which is capable of execution. This can only take place once a civil court plays an active role during the trial of the civil suit. The Honorable Supreme Court has called upon the civil court to resort to various option of obtaining assistance from local commissioner. I am not touching that area. I'm only concentrating on the execution part only. And thereafter, the Honorable Supreme Court has cited a law laid down by the Honorable Supreme Court also. In the year 1991, the law is Ghanshyam Das Gupta versus Anant Kumar Sinha, AIR 1991, Supreme Court 2251, in which the Honorable Supreme Court has observed that the provisions of the code as regards execution, the provisions which deal with the execution process, the Honorable Supreme Court has observed that they are of superior judicial quality. Then what is generally available under the other statutes? Whatever is available under the other statutes and what is available regarding the execution proceedings, the Honorable Supreme Court has observed that the provisions of the code which deals with the execution process are of a superior judicial quality. So what the Honorable Supreme Court has further observed is the judge being entrusted exclusively with the administration of justice. You see, we judges are entrusted exclusively only and only with the administration of justice. If the only function, the only assignment to us is to administer the justice, then the trust which has been imposed by the institution is expected to do better. We are expected to do better as far as the execution of a proceeding or a decree is concerned. The Honorable Supreme Court has further observed that with pragmatic approach and judicial interpretations, the court must not allow the judgment debtor or any person instigated or raising frivolous claim to delay the execution of the decree. You see, by interpreting those judicial provisions of the superior quality, by playing active role and by showing firmness, we can stop the judgment debtor from raising the frivolous claims and delaying the execution process. The Honorable Supreme Court has further asked the civil courts to obtain security before proceeding with the suit pertaining to the money claims. The Honorable Supreme Court has even said that the inherent powers provided to a civil court under the code through section 151 should be invoked for obtaining security before further progress of the suit in a case where a money is claimed. You see, while doing the execution proceedings, you must have noticed that in executing a decree in which money is claimed, you see, on the oral application, the judgment debtor can right away be arrested. And if an inquiry is to be conducted, whether he is to be sent to civil prison or not, then a security is taken from him. If the security can be taken during the execution stage, why not it cannot be taken during the stage of the civil suit only? So the Honorable Supreme Court, through this judgment, has sensitized us that this provision, section 151 CPC, which is a beautiful provision. You see, we are entrusted with a task to administer justice. For administering justice, we need to pass certain orders which are necessary for doing the justice, for administering the justice. But the code is silent about it. There is no judgment laid down by the Honorable High Courts or by the Honorable Supreme Court on the matter. Then to do what? We are not helpless then. We can invoke these provisions, the provisions provided under the code through section 151, and by invoking these provisions, we can pass any order which is necessary for doing the justice or for undoing the wrong, for stopping the wrong, for undoing the injustice. Now coming on to those directions, the Honorable Supreme Court has said that these directions have been passed in larger public interest to subserve the process of justice so as to bring to an end the unnecessary ordeal of litigation faced by the parties, awaiting the fruits of the decree, and in larger perspective, affecting the faith of the litigant in the process of law. With these pious objectives, these directions have been given by the Honorable Supreme Court. Before giving the directions, the Honorable Supreme Court has mentioned that all courts dealing with the suits and execution proceedings, all courts shall mandatorily, it is mandatory for those courts who are dealing with the suits and the execution proceedings to follow the said directions. It is mandatory. It is not discretionary with the courts. Now coming on to those directions. The first direction is in suits relating to delivery of possession. The court must examine the parties to the suit under 10 in relation to third party interest and further exercise the power under Order 11, Rule 14, asking parties to disclose and produce documents upon oath which are in the possession of parties, including declaration pertaining to third party interest in such properties. You see, ideally, it is the plaintiff which has knocked at the door of a civil court for obtaining an adjudication pertaining to his civil right. He is expected to join all those persons who are disputing his civil right, who are claiming otherwise, so that in their presence, the dispute in between all those disputing parties is settled for once and all. It has been seen that the relief is claimed pertaining to a property, but at the time of execution, it is found in possession of some other person, or on some part of that property for want of demarcation, there is found a third party in possession who was not party during the initial litigation in the civil suit. It complicates the matter. So, to avoid that complication, the Honorable Supreme Court has asked the civil courts to play an active role in examining the parties as to see whether the subject matter of the dispute is clear and there should not be any confusion about it. Thereafter, the direction is in appropriate cases where the possession is not in dispute and not a question of fact for adjudication before the court may appoint commissioner to assess the accurate description and status of the party. You see, there is a provision under the code for taking assistance from the commissioner, a person empowered by the civil court himself to do certain duties on behalf of the court. And if an assistance can be obtained from a commissioner by being appointed through a court, then such an assistance should be taken regarding accurate description of the property and regarding the accurate status of the property. Thereafter, the direction is after examining of the parties under Order 10 or production of documents under Order 11 or receipt of commissioner report, the court must add all necessary or proper parties to the suit so as to avoid multiplicity of proceedings and also make such joinder of cause of action in the same suit. You see, the interest of the administration of justice requires that all parties which are necessary parties, which are proper parties, without whose presence a dispute cannot be adjudicated, should be joined as parties to the dispute. Second thing is, all the disputes which are in between the parties should be joined in one litigation, so that the dispute for once and all is adjudicated in the presence of those parties, so that there is no different proceeding, no multiplicity of proceeding. You see, we have three provisions. One is Section 10 of the CPC, it asks these civil courts to stay the subsequent proceeding when a proceeding is already pending before a competent court of law. Section 11 res judicata says a civil court is barred to adjudicate a matter which was directly and substantially in issue in a previously adjudicated matter in between the same parties which has attained finality. Then is section 151 CPC. If a matter is not subject to stay, if a matter is not barred under the rules of res judicata, the matter is to be independently tried, then there is inherent power with the court to consolidate all those matters in one matter. The idea is the public policy that there should not be multiplicity of proceeding. There should only be one proceeding. All the parties should be joined in the proceedings. All the causes of action, all the reliefs, all the disputes should be settled in that very proceeding. Hereafter, proceeding with the next direction. Under Order 40 Rule 140 of CPC, a court receiver can be appointed to monitor the status of the property in question as custodia legis for proper adjudication of the matter. The Honorable Supreme Court has directed that in suitable matters where the appointment of receiver is in the interest of justice, the receiver should be appointed in those matters. Moving to the further direction, the court must, before passing the decree pertaining to delivery of possession of a property, ensure that the decree is unambiguous so as not only contain clear description of the property, but also having regard to the status of the property. So the direction is to pass clear, unambiguous, executable decree. Further direction is, in a money suit, the court must invariably resort to Order 21 Rule 11, the provision of oral application by the decree holder against the judgment debtor for executing a money decree, ensuring immediate execution of decree for payment of money on oral application. This provision we do not resort to for one reason or the other, but this provision is mandatory to be invoked. At the most, we can hold an inquiry after obtaining security from the judgment debtor, which can help us in implementing the decree, in executing the decree at the later stage. Moving on to the next direction. In a suit for payment of money, before settlement of issues, the defendant may be required to disclose his assets on oath to the extent that he is being made liable in a suit. The court may further at any stage in appropriate cases during the pendency of the suit, using powers under section 151 CPC, demand security to ensure satisfaction of any decree. So the court can invoke the provision under section 151 CPC when there is no express provision, but such an order is necessary for the ends of justice to administer the justice. The court can invoke the provision, and now it is the law of the land through direction passed by the Honorable Supreme Court, which is mandatory to be observed. Moving on to next direction. The court exercising jurisdiction under section 47, adjudicating the dispute at the stage of execution proceeding, under section 47 or under order 21 of the CPC execution proceedings, must not issue notice on an application of third party claiming rights in a mechanical manner. In a mechanical manner, in a routine, we are not to waste the time by issuing a notice to the party each and every time. Only in required cases, only for the interest of justice, the notice should be given, not in a routine or mechanical manner. Further, the court should refrain from entertaining any such application that has already been considered by the court while adjudicating the suit, or which raises any such issue which otherwise could have been raised and determined during adjudication of suit if due diligence was exercised by the applicant. This is a final rule of res judicata and constructive res judicata, which has been sensitized by the Honorable Supreme Court through this direction. That is, if during the trial a particular matter stands adjudicated, or the party was having a chance to raise that matter, the party would have raised that matter, or the party ought to have raised that matter, and that matter has not been raised, constructive res judicata, then such a matter is not open to adjudication during the execution proceeding. These same objections are taken again and again by the JD to delay the matter. If we check the file of the trial court that this matter has already been adjudicated upon, it can save our precious time in dismissing those objections at the threshold then and there only. Further direction is the court should allow taking of evidence during the execution proceedings only in exceptional and rare cases, where question of fact could not be decided by resorting to any other expeditious method like appointment of commissioner or calling for electronic materials, including photographs or video with affidavits. You see, what is seen is that during the execution proceedings also, the mini trial or a sort of trial is started by a civil court. You see, that should not be there in each and every case. That should only be in exceptional and rare cases. You see, even if we have to adjudicate upon an objection, it is not required that to adjudicate upon each and every objection, we call the parties to lead evidence. It will unnecessarily waste the precious time and will delay the execution of the decree. The Honorable Supreme Court has said that only in exceptional and rare cases where any fact is to be adjudicated upon, a new fact which was never adjudicated upon till that stage is to be adjudicated upon by taking evidence. And if we are to take the evidence should be taken of the electronic mode, of the electronic material. The photographs should be called upon, the videos should be looked into, and the parties should be asked to furnish their affidavits on the basis of the assistance from the local commissioner, on the basis of the assistance from electronic record, on the basis of the assistance from photographs, on the basis of the assistance from videos, on the basis of the assistance of the affidavits of the parties, we can dispose of the objections. This is a very handy direction through which we can expeditiously dispose the execution cases and well within 6 months. Moving on to next direction, the court must, in appropriate cases where it finds the objection or resistance or claim to be frivolous or nullified, resort to sub-rule 2 of Rule 98 of Order 21, as well as grant compensatory costs in accordance with Section 35A should be resorted. What is the provision is? Should be sent to civil imprisonment, should be imposed exemplary cost, suitably reasonable cost, if the objections are found to be frivolous or nullified. You see, the whole provisions are there for a party which has approached the court with clean hands, with a bona fide. The court is not to play in the hands of the party which has a malafide, which has a bad intention. Only it is if we come across that the party, the JD or the objector is having a mala fide, is having a bad intention, has no merit, his intentions are bad, we are not to honor such a party. We have to resort to the provisions of the code and expeditiously dispose of the execution case. Another direction is under section 60 of the CPC of the term, which talks about the properties which are attachable under law or the properties which are exempted from attachment. The term in name of judgment debtor or any another person by another person in trust for him or on his behalf should be read liberally. This provision should be given broader and liberal interpretation to incorporate any other person from whom he may have the ability to derive share, profit or property. Sometimes to outsmart the civil code, judgment debtor puts his partyman in the possession of the property to raise an objection by a third party, but that party is the partyman of the judgment debtor. The judgment debtor is deriving the share, profit or the rights in the property from that very person. Then the direction is to interpret liberally the term the judgment debtor or any other person in trust for him or on his behalf, and the same person should be treated at par or to be a judgment debtor himself. The other direction is the executing court must dispose of the execution proceedings within 6 months from the date of filing, which may be extended only by recording reasons in writing for such delay. So the direction is to dispose of the execution proceedings within 6 months from the date of their filing. It can be extended, but for extending, the reasons have to be recorded by the civil code for such a delay. So we are sensitizing all of us to those provisions which are handy for the expeditious disposal and those provisions which should be carefully invoked for issuing any process so that unnecessary time of the court in implementing the decree in favor of the decree holder is not wasted. The other direction is the executing court may, on satisfaction of the fact that it is not possible to execute the decree without police assistance, direct the concerned police station to provide police assistance to such officials who are working towards execution of the decree. You see, there is a provision in the rules and orders that police assistance can be sought from the commissioner of the police, from the superintendent of the police, from the SSP of the district, through the learned district judge or through the learned civil judge senior division. This is a time-consuming process. We have to dispose of the execution cases in 6 months. So practically, it appears to be a wastage of time. It is the court which is satisfied that for implementing this process, the police assistance is required. It is a law and order situation. It is directing the police to assist the official of the court, to the bailiff of the court, to implement the process issued by the court. Here, the channels were found unnecessary. So the direction is very much clear. The executing court can directly direct the concerned police station, the concerned SHO of the concerned police station, to provide police assistance to such officials who are working towards execution of the decree, the bailiff, the process server of the court. So under this direction of the Honorable Supreme Court, we can directly write to the SHO of the concerned police station to provide police assistance to the official of the court, to the bailiff of the court, to the decree holder, to the process server of the court. The further direction is further, in case an offence against the public servant while discharging his duties is brought to the knowledge of the court, the same must be dealt stringently in accordance with law. There can be an occasion where for one reason or the other, the SHO do not obey the order of the court. Willful disobedience to the order of the court, it will amount to a wrong, an offense. And if such an offense is committed by a SHO in such a case, such a case should be dealt stringently in accordance with law. That SHO, that police officer should be taken to task so that the orders of the civil code during the process of execution are honored, are taken care of, are implemented in its letter and in its spirit. The directions, ma'am, over to you.
Yes, sir. So while these directions, which have been very comprehensively laid down in this particular case, and this substantially touches upon all the practical problems that the officers face during execution. But sir, I would like to ask one question from you, and that is whether the execution application can be rejected for non-performance of the requisite formalities, which are sometimes imposed by the learned judicial officer.
Yes, ma'am. Thank you, ma'am. Before touching that provision, I am reminded of one thing. You see, Section 51 talks about the modes of execution of the decree. There can be different decrees, but the modes, the methods through which those decrees can be executed are only few. They are by delivery of any property specifically decreed, by attachment and sale of the property of the JD, by the sale without attachment of any property, by arrest and detention in prison, by appointing a receiver, in such other manner as the nature of the relief granted may require. So what I want to emphasize is that this is a mode, a method through which a judgment debtor is compelled, is enforced to honor the decree, to perform his part under the decree. So this is just a method through which a pressure is built upon the judgment debtor to honor the things. You see, there are two scenarios. First scenario is a normal scenario. A party has genuinely approached the civil court, which is there in 98 or 99% of the cases. He has joined all the necessary parties whose presence is required to adjudicate the matter. All the parties have taken all the reliefs, all the claims, all the causes of actions have been joined, and that matter is decided in totality and finally. Then no difficulty comes in its implementation. If any party to the litigation is raising any obstruction, is objecting to the implementation of the decree, then at the very threshold, he has no right. His intention is not bona fide, rather nullified. His intentions are bad. He is not to be honored. The other scenario is that a party who has approached the civil court for obtaining a relief, the plaintiff, he is to assist the court by standing on his own legs, by proving his pleadings through cogent and convincing evidence. It is that party only which approaches the court by moving an application for enforcing the decree, for executing the decree. If that party has concealed something from the court, has obtained a decree by concealing a material fact from the court, and the result is that is not a normal decree, there is a third party interest on the subject matter of the decree, which he has not made the party at the time of the trial, the result will be delay in the execution proceeding. But in this scenario, which are very few cases, the fault is of the plaintiff, the fault is of the decree holder, the fault is of the applicant. We are not concerned with those faults. We are only concerned with the faults which can be attributed to a civil court, that a civil court, by invoking the relevant provisions of the code, by actively participating in the execution proceedings, by firmly upholding the mandate of the law, did not make the decree implemented within a 6 months period or as early as possible. So coming on to the question of Ma'am Karuna, Rule 10 of Order 21 requires that whosoever desires, whosoever is the holder of the decree holder, whosoever desires a civil court to execute a decree which he is holding, he has to apply to the court. Without application, the court cannot implement a decree, cannot execute a decree. Then applications are of two types. One is oral and the other is written. The oral application is dealt under sub-rule 1 of Rule 11 of Order 21. It can only be made where a decree is for the payment of money. And on the oral application of the decree holder, at the time of passing of the decree, the executing court, the trial court, can order immediate execution thereof. How can an immediate execution of a money decree at the time of passing of the decree can be made? It can be made by the arrest of the judgment. If the decree holder makes you an oral request at the time of passing of a money decree in his favor, then under this provision, a executing court is to arrest such a judgment debtor. You see, we come across so many things in our mind that this is a judgment given by a trial court. There are provisions of appeal also. It has not attained finality. You see, the decree is only a money decree. In this very decree, the plaintiff has approached a civil court for obtaining such a decree. The party against whom the plaintiff has approached has appeared and has defended his case, or he must be ex parte. Then also it is his fault. After hearing the parties, after taking their evidence, after appreciating their pleas, after appreciating their evidence, a judgment is passed on the basis of which a decree is drawn. If that is so, a civil court which is entrusted with the task of administration of justice has decided a list on merits by appreciating the evidence which the parties have led as per the technical rules of laws of evidence, and only then the provision is, the intention of legislature is that such a judgment debtor on the oral application, on the oral request of the decree holder at the time of passing of the decree, in cases where the decree is for the payment of money, can be arrested prior to the preparation of a warrant if he is within the precincts, within the premises of the court. Second method, which is normal, is through written application. This is dealt under sub-rule 2 of Rule 11 of Order 21. It requires that every application for the execution of a decree shall be, it is mandatory, writing, signed and verified by the applicant or somebody on his behalf, and shall contain in a tabular form certain particulars which are necessary in the matter. The particulars, besides the number of the suit, name of the parties, date of the decree, is whether any appeal has been preferred from the decree. Particular is whether any, and if any, what payment or other adjustment of the matter in controversy has been made between the parties subsequently to the decree. Then whether any and if any what previous applications have been made for the execution of the decree, the dates of such applications and their results, the amount with interest, if any, due upon the decree or other relief granted thereby, together with the particulars of any amount of cost, if any, awarded, the name of the person against whom execution of the decree is sought, and important is the mode in which the assistance of the court is required. You see, in execution proceedings, a civil court is assisting a decree holder in obtaining the fruits of his decree. The decree holder is to specifically mention in writing as to through which mode the assistance of the court is required. You see, the decree holder is the master of his litigation. He knows the opponents, he knows the judgment debtor, he knows the defendant, he knows the ground realities. It is he who is to approach the court by suggesting a particular mode for seeking assistance of the court in execution of a case. That modes are by delivery of any property specifically decreed, by the attachment and sale, by the sale without attachment of any property, by the arrest and detention in prison of any person, by the appointment of receiver, or otherwise as the nature of the relief granted may require. And last but not least, the court may require such a decree holder applicant to produce a certified copy of the decree. Then Rule 11A of the said order talks about the grounds to be stated by the decree holder applicant if he is seeking the arrest and detention of the judgment debtor in prison. And the statement of those grounds should be supported by an affidavit of the decree holder applicant, by stating specifically therein the grounds on which the arrest is applied for. You see, arrest is taking away a constitutional right of a person of liberty, of remaining free. By detaining him in civil prison, you are curtailing his constitutional right. It cannot be curtailed in a routine manner. There are certain parameters which have to be met before sending a person to civil prison, which we shall be dealing in the later portion of the session. Then is Rule 12 of Order 21. It talks about the annexing with the application an inventory of the property to be attached, which belongs to judgment debtor, which is a movable property, but is not in the possession of the judgment debtor. So an inventory of such a property containing a reasonably accurate description of the property should be annexed with the application for obtaining relief by the decree holder applicant. Then comes Rule 30. It talks about providing the required description of the immovable property belonging to the judgment debtor, where its attachment is sought. And that description should be sufficient to identify the said property. In case such property can be identified by boundaries or numbers in a record of settlement or survey, a specification of such boundaries or numbers, a specification of the judgment debtor's share or interest in such property. We are only to attach the property of the judgment debtor, which is sufficient to execute the decree. Not less than that, not more than that. To the best of the belief of the applicant and so far as he has been able to ascertain the same. These descriptions have to be given by the decree holder applicant to the best of his belief, and which he has ascertained, which he has been able to ascertain. Then is Rule 17. What is the procedure on receiving an application for execution? Sub Rule 1 says, on receiving the application for execution of a decree, the court shall ascertain whether such of the requirements of Rules 11 to 14, which we have just discussed, which are applicable to a particular case, have been complied with. Whether all the requirements of those rules have been complied with by the applicant decree holder. And if they have not been complied with, the court shall allow the defect to be remedied then and there. If the copy of the decree is not there, if the description of the property is not there, if the inventory is not there, then the court is to permit the decree holder applicant to do the needful, to remedify the defect then and there only on the said date, no adjournment for the same. Or if it is such a remedy which can only be removed after consuming few days within a time to be fixed by it. And here I insist that if you fix a time for the removal of the defect, for the remedy of that defect, fix a reasonable time. 3 days time, 4 days time, weeks time. Don't give month or 2 month or 6 month adjournment for the same. That would be unjustified. That will delay the disposal of the execution case in an expeditious manner. So the rule is it should be remedied then and there, or a reasonable time should be given to fix it up, to remove the defect. Then sub rule 1A is what we are talking about. The defect has not been removed then and there. The court provided a reasonable time for the removal of the defect. It has not been removed even after providing a reasonable time from the court. Then what is the remedy? The remedy is the court shall, the word is shall, it is mandatory, reject the application. Don't keep such an application on your board. It is the decree holder applicant which is to approach a civil court for seeking the execution of his decree. Only we are giving to him is the assistance. The mode is to be suggested by him. The requisite formalities has to be fulfilled by him. If he do not fulfill the formalities, if he do not perform his part, even after being provided a reasonable time, then he is not entitled for any further adjournment, for any further relief. His application should be rejected then and there. Then is in this when we talk about rule 17, then there is a provision to sub rule 4, which assumes significance to be mentioned in this very session. It provides that in the case of a decree for the payment of money, the value of property attached shall, as nearly as may be, correspond with the amount due under the decree. So whenever we have to attach a property of the JD, we should be cautious and careful that we should amount the property of the value which is nearly or which corresponds and reject the application then and there. Over to you, ma'am.
Thank you, sir. So my next question is we have seen that one of the direction in the case was that notices have to be issued very carefully, and sometime notice has to be issued and sometimes there is no need to issue the notice. So sir, I would like to ask when in execution a notice is required to be issued and when there is no such requirement.
Yes, ma'am. Rule 22 of Order 21 deals with issuance of notice. Notice to show cause against execution. But as the title says it is only in certain cases. Let us see which are those cases. Let us deal with Subrule 1 first. Subrule 1 provides the court executing the decree shall issue a notice to person. Here it is mandatory. It is required by an executing court to issue a notice to the person against whom execution is applied for, who is the judgment debtor in the execution application, requiring him to show cause on a date to be fixed why the decree should not be executed against him. This notice is compulsory. This notice is mandatory to be issued to the judgment debtor to show cause why decree should not be executed against him, but only when the application for seeking the execution application is made, is presented after more than 2 years from the date of decree. You see, the decree holder, we are talking about expeditious disposal of execution application. Execution applications are moved by the decree holder to realize to obtain the fruits of the decree. So in an ideal or normal situation, a decree holder will approach the executing court soon after his decree attains finality. He will not wait for more than 2 years for approaching the court. It can be in very rare cases. If that is a rare case, then notice has to be given to the JD to look into as to what are the circumstances that the decree holder has not moved the application for a period of more than 2 years. So in 99.9% cases, the execution application, and in 100% cases, the genuine cases, the execution application is moved soon after the finality of the decree, that is within a period of 2 years from the date of decree. If that is the scenario, then no notice is required. Otherwise, notice is required. Then second category of the cases in which the notice is required is when the decree is sought to be executed against the legal representative of a party to the decree. You see why this is so? Because a legal representative was only representing the interest of the person who has died in a particular litigation. He was only representing the interest. He was not that person himself. Legal representative liability is very restrictive. The liability is only to the extent to which he has inherited the interest of the deceased. So to know it, so that no injustice is caused to such a legal representative, there is a provision under which a notice becomes necessary to be given to such a legal representative. The third scenario is where an application is made for execution of a decree filed under the provisions of section 44A. 44A deals about decrees passed by courts in reciprocating territories. So it is a decree which is under execution, which is passed by a court in reciprocating territory, in a different territory. If that is the scenario, then also the interest of justice demands let a notice be issued to the judgment debtor. Then the last category and last requirement is against the assignee or receiver in insolvency, where the party to the decree has been adjudged to be an insolvent. A decree was passed against a party who has been adjudged, who has been declared as insolvent. His interest has been assigned to a particular person. His interest has been received. The interest of an insolvent has been received by a person. If a decree is to be executed against such a person, the interest of justice demands the legal provision is that notice is to be given to him. Otherwise, there is no requirement to issue notice. Furthermore, there is a proviso to Subrule 1. It also provides that no such notice shall be necessary, is necessary, in consequences of more than 2 years having elapsed even in a case where two years or more than 2 years have lapsed between the date of the decree and the application for execution. If the application is made within 2 years from the date of last order against the party against whom execution is applied for, made on any previous application for execution. If any order has been passed in between the parties from the date of the decree and in any application for execution preferred by him within 2 years, though the decree passed is of more than 2 years, even then there is no need to issue the notice. The requirement is that in an execution application filed by a party, an order has been passed by a court and the time gap in between the said order and the present execution application is not of more than 2 years. Then there is sub-rule 2 also of this rule, which says the court can issue any process in execution of a decree without issuing the notice thereby prescribed. In those 4 circumstances also, the court can bypass those provisions and can issue the process without issuing the notice if it considers that the issue of such notice would cause unreasonable delay or would defeat the ends of justice for reasons to be recorded. The court is just required to record reasons that I am not issuing this notice to this party, though it is required under this provision, because I consider that issue of such a notice would cause unreasonable delay, which will defeat the ends of justice, which will not be in the interest of justice. If this is the scenario, in a given case, by recording reasons, you can directly proceed to execute the decree without issuing the notice, though it is so required under this provision. Yes, ma'am, thank you. Over to you.
Thank you, sir. My next question is, can the court monitor the execution of the process, because that is also a stage when the delays are caused and that further delays the execution?
Yes, ma'am. The actual word which has been used by the Honorable Supreme Court in the judgment which I have mentioned at the start of the session is that the court is to play active role. If court plays an active role, whatever is the stage before the court, whatever is the proceeding before the court, court will be in a position to administer justice. If the court loses his active participation or active role or overseeing or monitoring the things, then the administration of justice will suffer to some extent. Let me deal certain provisions which we monitor or minutely observe can save us from wasting unnecessary time. You see, first is Rule 24. Under Rule 24, the process for execution is provided. Under this process, the court is to issue its process for execution of the decree, warrant of attachment, warrant of possession, etc., etc. Every such process shall bear date, the day on which it is issued, and shall be signed by the judge, and shall be sealed with the seal of the court and delivered to the proper officer to be executed. Sub-rule 2 says the process which is to be issued by the court should bear the date, the day on which it is issued. It is to be signed by the judge, and it is to bear the seal of the court, and it is to be delivered to the proper officer to be executed, the execution clerk. Then is sub-rule 3, which is important. It says, in every such process, a day shall be specified on or before which it shall be executed. And a day shall also be specified on or before which it shall be returned to the court, but no process shall be deemed to be void if no day for its return is specified herein. You see, what we have seen is that only issuing proclamation of sale, we fixes dates for the execution of the work and for the return of the work executed by the official of the execution agency with its report to the court. But in other cases, we do not fix those dates. Under sub-rule 3 of Rule 24, we should specify the days, the date on or before which the bailiff or the process server is to execute the process. And the day is also to be fixed on or before which it is to be returned to the court. You see, what will happen is, if this is not done by the bailiff or the process server, then it will be, you see, violation of the order of the court. It will be insubordination. Then is Rule 25. It talks about the endorsement on process. Endorsement to be made by the process serving official. Sub-rule 1 says the officer entrusted with the execution of the process shall endorse thereon on the process the day on which it was executed. The process server who has been entrusted with the process of the execution on the process shall endorse, shall write, shall report, shall mention the day on which it was executed and the manner in which it was executed. Important is, if the latest day specified in the process for the return thereof has been exceeded, if the last day has been exceeded, the process serving official is to endorse, is to mention, is to report the reasons of the delay. You see, we have to see that what are the reasons which are endorsed, which are mentioned, which are reported on the process by the process serving official. If the process is not executed, then is again, if it was not executed, earlier was if it is delayed. Now is if it was not executed, the reason why it was not executed. So the process serving official is required to give reasons for the delay in execution and for the reasons for not executing the process, for not performing his duty, and shall return the process with such endorsement to the court. You see, we only examine the bailiffs where the police assistance application is moved. We do not examine, we do not seek an explanation from the bailiff or the process server if he delays the execution of or if we do not execute the process. This is a very important provision which should be invoked if there is a delay in the execution process or if the execution process is not, you see, implemented, to make that process server accountable. Once you seek the explanation for the reasons of the delay, for the reasons of not implementing the court order, the said process of server or all other process server serving officials or the establishment will take you seriously and will honor your processes in time. If your processes are honored in time, are executed in time, you are able to dispose of the execution application in time. So it is very necessary to monitor or to keep a check on the process of execution. It is your process which you have issued. Your process has to be implemented by the process serving official. If he does any delay or if he is unable to execute it, do examine him, do call his explanation, do punish him under the relevant law. Sub-rule 2 says where the endorsement is to the effect that such officer is unable to execute the process, the court shall examine him, touching his alleged inability to see whether the inability was genuine or was fake. Was there any malafide in it? And may, if it thinks fit, summon and examine witnesses to such inability and shall record the result. So a court, an executing court, is to monitor its processes, whether the process serving official has made the required endorsement, if he has given the reasons for the delay, whether he has given the reasons for his inability, and then we have to look into those reasons, those inability, whether it is genuine or it is ingenuine. Yes, ma'am. Over to you.
Yes, thank you, sir. Sir, my next question is there any provision under which the judgment debtor can be asked to furnish details of his properties? And in case he does not furnish those particulars despite the order of the court, then what actions can be taken against him?
Yes. This is provided under Rule 40. Proceeding on appearance of judgment debtor in obedience to notice or after arrest. Subrule 1 says, when a judgment debtor appears before the court shall proceed to hear the decree holder and take all such evidence as may be produced by him in support of his application for execution, and shall then give the judgment debtor an opportunity of showing cause why he should not be committed to civil prison. Subrule 2 says, pending the conclusion of the inquiry, the court may, in its discretion, order the judgment debtor to be detained in the custody of an officer of the court or to release him on his furnishing security to the satisfaction of the court for his appearance when he is so required. Subrule 3 says, upon the conclusion of the inquiry, the court may, subject to the provisions of Section 51 and to the other provisions of this code, make an order for the detention of the judgment debtor in civil prison and shall, in that event, cause him to be rearrested if he is not under arrest. Then is proviso to Subrule 3, in order to give the judgment debtor an opportunity of satisfying the decree, the court may, before making the order of detention, leave the judgment debtor in the custody of an officer of the court for a specified period not exceeding 15 days, or release him on his furnishing security to the satisfaction of the court for his appearance at the expiration of the specified period if the decree be sooner satisfied. You see, before adverting to the query of Madam Karuna Sharma, I was missing this important thing to be told, is that these provisions have been inserted in the Code of Civil Procedure with an object that no injustice is caused to anybody. In a case where decree holder is seeking the arrest and detention of the judgment debtor in a civil prison, that can be on two accounts. First account is that the judgment debtor is not paying the money due to the decree holder. Second is that he is not obeying the order of the court. In order to pressurize him, he is to be detained and sent in civil prison. These two procedures are dealt separately under the code. You see, these safeguards are provided to ensure that the decree holder who has the means of paying the money and who is intentionally not paying the money is sent to prison for pressurizing him to pay the money. But if the decree holder has no resources to pay the money, has no money to be paid, he is insolvent, then the interest of justice will not be served by detaining him in civil prison. So these checks, these balances have to be maintained in a case where a judgment debtor is to be sent to the civil prison. Then there are certain things which have to be seen while issuing a warrant of detention. That is, a woman cannot be arrested, cannot be detained in a civil prison in execution of a decree for money. If a woman is to pay money under a decree, in execution of that decree, a woman cannot be detained in civil prison. Then there is a period for which the detention can be there. It is only for 3 months if the sum of the money to be realized is more than 5,000. That means more than 3 months you cannot detain a person. The detention period is only 6 weeks if the sum of money is exceeding rupees 2,000 but is less than 5,000. And for a money less than 2,000, no detention can be ordered. If a person is detained and he is not discharged from his debt, but the thing is, he cannot be re-arrested in the same execution application. Now coming on to the question of Ma'am Karuna. It is Rule 41, which deals about the examination of the judgment debtor to his property. This rule only talks about the examination of a judgment debtor as to his property, where a decree is for the payment of money and not otherwise. But under the provision of Section 151 CPC, inherent powers, you can ask a judgment debtor to disclose his assets in other cases also. But the Rule 41 deals with where a decree is for payment of money. Sub-Rule 1 says, where a decree is for the payment of money, the decree holder may apply to the court for an order that the judgment debtor or any other person be orally examined as to whether any or what debts are owing to the judgment debtor and whether the judgment debtor has any and what other property or means of satisfying the decree. And the court may make an order for the attendance and examination of such judgment debtor or officer or other person and for production of any books or documents. You see, it is a scenario where the decree is for the payment of money and the decree holder applicant is not knowing certain things which only a judgment debtor can know regarding his debts, regarding his assets, regarding his liabilities. To know those debts and those assets, it is necessary for the implementation of the decree. So if that is the scenario under Sub-Rule 1 of Rule 41 of Order 21, a decree holder of a money decree can apply to the court for the examination of the JD. Sub-Rule 2 says, where a decree is for the payment of money and has remained unsatisfied for a period of 30 days, the court may, on the application of the decree holder and without prejudice to its power under Sub-Rule 1, by order, can pass an order, require the JD or where the JD is a corporation, any officer thereof to make an affidavit stating the particulars of the assets of the JD. The court can call upon, on the application of the decree holder, to file an affidavit by the JD as to the assets which the JD owns, because from those assets, through the attachment and sale of those assets, he will be pressurized, he will be enforced to implement to honor the decree. Sub-rule 3 says, in case the JD disobey the order passed by the court, do not appear, do not file the affidavit, do not disclose his assets, then the court is not helpless. The court may direct the person disobeying the order to be detained in civil prison for a term not exceeding 3 months. Such a disobedient JD or an accountant of the JD or an agent of the JD can be detained in civil prison for such a disobedience for a term not exceeding 3 months. So the court is not helpless. The court is not teethless. If the JD, after passing of your order, do not come present, do not file the affidavit, do not disclose his assets, then such a JD is to be detained in civil prison for a term not exceeding 3 months. And then there is no inquiry required to be conducted to know whether he has resources for the payment of the money. Here, the person is being imprisoned in civil prison for disobeying the order of the court. So directly he has to be sent in the civil prison. Unless before the expiry of such term, the court directs his release. Yes, ma'am.
Thank you, sir. So moving towards the end, my last question will be, what are the other provisions to be invoked for expeditious disposal of the execution, and what are the relevant concerned provisions of the Honorable High Court rules and orders in this regard?
Yes, ma'am. You see, I would like to sensitize the officers that section 60 of the code tells us about the properties which are liable to attachment and sale, and the properties which are exempt from attachment and sale in execution of the process. As and when a warrant for attachment or a sale of a property is to be sent, then it has to be ensured by the court that such property should be capable of attachment. If, as said earlier, a court issues a process attaching a property which is not capable of attachment, the entire time will be wasted. The result will be delayed, and the delay will be on the part of the court for not actively taking interest while issuing the warrant of attachment. There is a difference in between the attachment of the salary in decree for maintenance and otherwise. 1/3 salary is to be attached in execution of any decree for maintenance. Otherwise, salary to the extent of 1000 rupees and 2/3 of the remainder in execution of the decree has to be attached. In cases which are not the cases for execution of a maintenance decree, there is a proviso that where any part of such attachment of salary as is liable to attachment has been under attachment, whether continuously or intermittently for a total period of 24 months, 2 years, such portion shall be exempt from attachment until the expiry of a further period of 12 months. If a salary has remained attached for a period of 2 years, either continuously or at different intervals, such salary becomes exempt from attachment thereafter till 1 year, till 12 months thereafter. And if you have to attach the salary again after the break of 1 year, after the break of 12 months, then and only then you can attach the salary of such a person. And where such attachment has been made in execution of one and the same decree, the attachment after the said period, the salary will be finally exempt from attachment. In one execution application, the maximum period for which you can attach a salary of a salaried person is 24 months. If there are different execution applications and the salary under attachment has remained continuously or intermittently for a period of 2 years, then you have to give a break of 12 months, 1 year period. Then there is a minor sensitivity to be discussed with the officers. There is a minor difference as far as attachment of a salary of a government servant or attachment of a salary of a private employee is concerned. If we have to attach the salary of a government servant, it does not matter under Rule 48 whether the JD or his DDO, disbursing officer, is within your local jurisdiction or is outside your local jurisdiction. But under Rule 48A, if the salary of a private employee is to be attached, it can only be attached where the DO, disbursing officer of the said employee, is within the local limits of your jurisdiction. If we overlook this provision, we waste precious time, and the result is delay in concluding the execution process. Then there is another important area which is often overlooked by the officers. Rule 50, execution of decree against firm. You see, if a decree is passed against a firm, it is to be executed against the firm, against the property owned by the firm. It cannot be executed through the personal property of the partners. And the rule is, the provision is, only those partners can be impleaded as judgment debtors who have appeared in the litigation in the civil suit in their own name as partners, or who have admitted or who have been declared, who have been adjudicated upon as partners. Only those partners can be made JD, and they can be sent to civil imprisonment. They can other processes can be issued, but their personal property cannot be attached and sold in execution of the process, because the decree is against a firm, a partnership firm, a corporation. So the property of the firm matters for realization of the fruits of the decree. Sub-rule 2 of Rule 50 says, if a decree holder intends to proceed against a partner which has not been made partner in the proceeding, then he has to seek the leave of the court. Then he has to apply to the court for seeking leave, and the court will grant him permission, the leave. Thereafter, such a partner can be proceeded against, otherwise not. Then is Rule 58. It tells us that it talks about the adjudication of claims to or objections to attachment of property. It says no such claim or objection shall be entertained where, before the claim is preferred or objection is made, the property attached has already been sold. Such a claim or objection will be infructuous. Second is where the court considers the claim or objection was designedly under a design or unnecessarily delayed. If there is unnecessary delay in moving the objections, such an objections are not to be entertained, are to be rejected then and there under Rule 58, and we can save the precious time. Then is Rule 66. If the JD has not joined the proceedings when the terms of the settlement of proclamation of sale was settled, then he is to be given a notice under Section 66. After the notice to the decree holder and the JD, the sale process is to be initiated. Then one more thing is, a difficulty is witnessed by the executing courts that nobody comes forward for purchasing the property. Then civil court becomes helpless. You see, there is a provision under Rule 67 of the Code, Order 21, Sub-Rule 2, that the proclamation is to be published also. The court can also direct the publication of the proclamation of the notice of the sale. Where it can be published? It can be published in the official gazette, but official gazette will only go to the officers of the government. The other provision is or in a local newspaper. So in my humble opinion, if a proclamation notice regarding the sale of a property is given in a local newspaper, it will give a wider publicity, a more broader publicity, and more people can participate in the public auction. And there are more chances that such a property is sold in auction. The provision is or in both. And the cost of such publication shall be deemed to be the cost of the sale to be borne by the JD. So we should also invoke this provision that the proclamation notice besides at the courthouse should also be published in a local newspaper and the official gazette at the expenses of the JD. Then is time of the sale. You see, we have to fix the dates for the sale. Then we have to take note that if a property to be sold is an immovable property, there should be a time space of 15 days in between the fixation of the proclamation notice at the courthouse and the day of sale. And the time space is to be minimum 7 days in case of movable property. The sale can be adjourned under Rule 69 for unforeseen circumstances. If the sale gets adjourned for a period of more than 30 days, then a fresh proclamation under Rule 67 is to be issued. Then the court cannot proceed further from the same stage. Then is while issuing the warrant for sale, we have to take note of things. If a sale is to be held through public auction, the money by the successful bidder has to be paid then and there. I'm talking about the sale of movable property. If the money is not paid then and there, then such a sale has to be conducted afresh. If while issuing your process, you mentions it, you direct the public auctioneer or the authority to whom you have entrusted the function of public auction of that property, that in case the successful bidder do not pay the money then and there, the sale be reconducted, the property be resold, so that the precious time is wasted. One more thing is Rule 82. It says the order for sale can be made by any court, but not by a court of small causes. So a court of small causes we have in Amritsar. There must be some courts in Haryana also. A small cause court cannot order the sale of immovable property. It is barred under Rule 82. As in movable property, in immovable property, the successor bidder is to deposit the 25% of the purchase money then and there to the officer conducting the sale. We can order that if the 25% money is not paid, then it is to be resold. Then again the bids are to be, so that the time is saved. Then is Rule 98, which we have discussed under the Supreme Court judgment also. It says the court can direct the person, the decree holder, the applicant to be put into possession of the property, can issue the warrant for putting the applicant decree holder into the possession of the property after adjudicating the objections, if any, raised by any of the party. Then is if still a resistance is shown. You see, what is the stages the objections were raised, it were dismissed. The court has ordered that decree holder applicant be put in possession. Even then resistance or obstruction is shown by somebody, then the provision says such a judgment debtor or such a person acting at the instigation of the judgment debtor or such a person acting on behalf of the judgment debtor be detained in civil prison for a term which may extend to 30 days. Such a defaulter should be detained in civil prison for a period up to 30 days. This provision should also be resorted. And then coming on to the rules and orders of the Honorable High Court, the relevant provisions are in Volume 1, Chapter 12 talks about the execution of the decree. Part A is a general chapter. Rule 2 of Part A is relevant. It says that special day to be reserved for execution work. The rule says execution of decrees should receive the same attention from the courts as original civil work and should be methodically and regularly dealt with as expeditiously as possible. Even before the mandate of the Honorable Supreme Court in Rahul S. Shah judgment, there is a provision in our rules and orders that the execution process should receive the attention of the court, the same attention which we give to original work. The same attention should be given to execution work, and the execution cases are to be disposed of as expeditiously as possible. Further, as a rule, one day during the week should be reserved for execution works so as to ensure proper attention being paid to it. Sometimes 2 days are necessary. So a days should be dedicated to the execution work. Without dedicating the requisite days as per the pendency of the execution work, we cannot justify it. District judges are responsible for seeing that proper arrangements are made for the execution work by all courts subordinate to them. The Honorable District Judges are casted a responsibility for overseeing the same. Then is Rule 5. District Judge to see that execution work is not neglected in lower courts. Close supervision and control should be exercised by the district judges over the execution of decree business pending in all courts subordinate to them, and where any officer is found habitually to neglect his branch of work or to dispose of it in a perfunctory casual manner, he should be reported to the High Court. Then is Part C, power of the executing court. An executing court cannot go beyond the decree. Its function is to execute the decree as it stands. Then is Rule 5, execution of decree pending appeal. If an appeal is pending, we are not to stay the execution process. Rule 5 says it is no bar. Then is Part E, procedure on application for execution. It talks about invoking Rule 24, Rule 25, fixing a day for the execution of the work. Rule 45, seeking the explanation of the officials. Rule 11 categorically asks us to invoke those provisions. Then is Rule 33, period of pendency. You see, Rule 13 says if the decree holder has realized his installment or has obtained the satisfaction asked for in the application for execution, the case should be struck off, even though a portion of the decree shall remain unexecuted. This says if a decree holder has asked for a particular mode for realization of a particular relief, once the relief is given, the execution should be disposed of, though part of the relief is still pending. Similarly, the case should be dismissed if the applicant for execution does not take necessary steps to prosecute his application. It is otherwise also if the decree holder do not file the list of the property for issuance of warrant of possession, warrant of attachment, then under Rule 13 of this very chapter, blamed for the mistake or lapse of the decree holder. Let the decree holder suffer. the court should record its reasons for the action taken in such cases. Then is attention, then is attachment. The Rule 4 says the court should be conscious while attaching properties. Rule 4 says the presiding officer will carefully scrutinize and will obtain a note from the reader that all the legal formalities are complete at the time of the issuance of warrant of attachment. Seek the report of the reader, go through the report and signs the report. Then is important thing is Part J. Part J, objections to attachment. Rule 1 says the objections under Rule 58 are to be disposed of in a summary manner. They are of a summary character. No need to call the detailed evidence. And if the evidence is required to be called, take the photographs, take the assistance of the local commissioner, take the video, take the electronic record into consideration. Rule 2 says that if any objection appears to be unnecessarily delayed or is designed to be delayed, the court has power to refuse to investigate the claim and dismiss the objection. This is all regarding the important provisions which are handy in timely disposal of the execution cases, or which can be consciously invoked, carefully invoked, so that the precious time of the court is not wasted. Yes, ma'am, over to you.
Thank you so much, sir, for such an informative session.
Sir,
we received certain questions, but I think most of them have already been answered. Still, I have two questions which I would like to ask.
Yes, ma'am.
So one question is when the Honorable High Court or Supreme Court passes an order saying stay notice in the stay application, stay which is what is this question? When the Honorable High Court or Supreme Court passes an order saying notice stay, does it mean that the execution process has been stayed or the court should proceed with the execution?
No. Only the Superior Court, the Honorable High Court or the Honorable Supreme Court has issued a notice. Unless and until a specific order is passed either by the Superior Court regarding the stay of the proceedings or the court which has passed the decree, the execution proceedings are to be proceeded with. It is just a notice, no stay. Yes, ma'am.
Yes, sir. So there were two questions which have already been addressed with regard to decree for recovery of money. So the question was, what steps are necessary to be taken before sending a judgment debtor to civil imprisonment? Yes,
to retreat them, that only that person is to be sent to civil imprisonment who has the resources to pay, who has a bona fide intention, who is leaving the jurisdiction of the court, who has something bad on his part. If a person has no resources, such a person is not to be detained in civil prison. Yes, ma'am.
So one question is, sometimes a party is awarded a decree for permanent injunction as the name of party surfaces in revenue record. But when they file an execution, they claim that they have been dispossessed after passing of decree. So should we take evidence of dispossession or in lieu of decree order warrant of possession?
You see, in a civil suit for seeking relief of injunction, permanent injunction, the plaintiff makes that person as the party who is threatening to interfere in his possession. If a person is threatening to interfere in his possession, then he should be made party and the list should be adjudicated in presence of those parties. If the threat do not remain there from that very person, then the plaintiff has to withdraw his suit. Or if a new person starts threatening, then a new suit has to be filed against another person. So if a person is dispossessed, the court has to adjudicate this list as to who has dispossessed him and as to when he has been dispossessed. only thereafter a decree is to be passed, and it is the decree which is to be executed by the court.
Sir, the question was that the decree has already been passed and the person has been dispossessed in between the passing of the decree and execution of the decree of the permanent injunction.
If you see, a decree can only be enforced against a party to the decree. If somebody has interfered in his to take back the possession.
Right. So then there are two questions in relation to the execution in family matters in maintenance cases.
Now we are going to conduct a special 2 days session for that. We'll be taking those cases there.
Right, sir. So, sir, we have these are the questions. So I thank you, sir, on behalf of all the judicial officers for guiding us on this very important aspect of execution. And I hope everybody will be benefited by this. Thank you all for attending today's webinar. Thank you once again. Namaskar.
Thank you, officers, and sorry for taking so much of the time. Thank you.